Everybody. This is Sam Shihab, with me, my good friend Brian Burke. We are attorneys with the law firm of Sam Shihab and Associates. We're immigration lawyers, and we talk about immigration law. And
I should hope so.
yes, and our weekly presentation is about current immigration events. We zoom in on an issue, break it down, trying to figure it out, and also answer any questions you have. We have a lot of fun doing it. And today we're going to talk about the budget reconciliation bill. Where does it stand?
Well, got the budget reconciliation bill, and also the DHS spending bill, which the Senate announced, hey, here's our version of it, and it has a visa recapture provision in it as well.
Yes, so there's a lot of things going on, and people saying this is very confusing. What's going on? So we're going to try to explain it to the best of our abilities, because we can finish explaining it today, and something can happen a few days from now and change things around. We're going to also going to ask a couple questions. We're going to ask, if we have time, is what's going on fair? We want your input, so we want to have a conversation with you. We're trying something new here to get your input in the conversation. And also, we're going to talk about any questions you have.
So our usual fun question fest. That's my favorite part.
So there's two things going on here that is confusing everybody.
Yeah.
We have the budget bill.
The big budget reconciliation that is news headlines, and you keep on hearing about Kirsten Sinema and Joe Manchin, who are the holdouts for the Democrats, preventing them from getting this passed.
Yes. Right? And in it is section 60,002.
Yeah. That's a lot of sections, man.
Yeah. 60,002 that has the Biden's
the 30-year visa recapture extravaganza
of 1 million green cards.
Yeah, splits pretty evenly amongst the employment and family-based categories, but a good bump forward. And we talked about that in past sessions. Yeah.
So that is going on, and we were just checking the news a few minutes ago, and everybody's saying, "Well, why this is gonna go forward because they've dumped the legalization portion of it."
Well, it's not officially dumped yet, because but it's basically seeming like it's gonna get there. I mean, the parliamentarian said no twice so far. There's maybe an option C, but they haven't run that through here as far as we can tell, and it's just out there. But everybody's saying, I mean, we were just looking at the news headlines, 20 minutes ago, and it's Manchin, one of the holdouts, saying, I think we get something we get a framework we can agree upon this week. And I heard Nancy Pelosi saying that on the whatever those talking head news shows over the weekend.
And 60,002, which is recapturing all the lost green cards for the last God knows how long, is still there. It's not gone.
Yeah.
And just let's go over that section, what it does. We've discussed it before, so remind everybody, what does that 60,002 section do for employment immigration?
Well, essentially, every year, it's not visa wastage is not a new 2020, 2021 phenomenon. It has been happening for the last 30 years. And this is part of President Biden's originally proposed legislation, and has made it into this budget reconciliation bill. And ultimately, it provides for recapturing all those visas. It says we're going to look back to 1992 to 2021, I believe it, all these fiscal years, and we are going to make available these visas in their respective categories. And we talked about this in a session a little while ago, Sam. And basically, this was kind of the most favorable, the most best, greatest visa recapture option.
And it does make the immigration numbers whole as far as congressional intent. So Congress wrote a law that was voted by representatives who represent elected by the people of this country, and they passed a law where they allocated certain number of visas for immigrant petitions and family petitions. And year in and year out, the administration or the immigration office, whether it was the INS back then or Department of Homeland Security now, have failed to issue the required number of visas year in and year out. So basically, all what this bill does is recapture those and say, this is what we have voted on, this is what we should do, because we're getting incredibly behind on issuing green cards and the waiting period. So that bill is in the budget today. It has not moved out. It has not been removed. Nor have we heard that the parliamentarian is objecting. We don't know anything about it, but surprises can happen.
Yeah. Well, again, we talked about this. It doesn't seem to be controversial. There's bipartisan support. We've all heard all sorts of bills from, more or less support voiced from Republicans and Democrats. And our big talk was, if they have this, it's in this bill, but is this bill going to get approved? Are we going to make it through the Senate? And it's looking to be close.
When everybody's saying, well, okay, we dropped option 1 and option 2, or option A and option B for the legalization, seems to be there is enough momentum to say, let's move this thing forward. There's a lot of people who are upset.
Yeah, I mean, it seems like, though it's not official yet, it seems like the legalization might be on the chopping block to get something passed. I mean, there's a lot of things on the chopping block. There's, I heard, free community college, things like that. So it's not just this, but in order to make an agreement, a lot of people have to be made unhappy, and that's what seems to be happening.
Yes. So far so good. We like what we see. Keep our fingers crossed and see. Let's see what happens. On the other side, we have the
DHS budget bill,
which was just released on October 18th.
Yeah. So there's the House one's been around for a while, and then there's the Senate one. The Senate comes out of their Appropriations Committee saying, "Here's our version of the House bill." And this is sort of, comes up in the news feed a little bit, and it has a little provision in it that originally originated with a member of the House, and of course, their bills tend to be similar because ultimately they have to come to an agreement and pass the same bill. And what's that? What's the name of that?
It's Meng.
Meng.
Grace Meng is a representative from New York. She basically have done a lot of things that are very interesting. I took a look at her list of bills that she introduced throughout the years. Some of them are immigration related. She's definitely somebody who is of an Asian descent, and
might be more sensitive to the topics of immigration.
Yeah, and she proposed, and then obviously she comes from a family unification background. So the Meng Amendment is a piece of legislation that is very easily written, very simple language. I'm being sarcastic. It is a very convoluted piece of legislation for anybody that doesn't read this day in and day out. And in essence, it basically really does not favor employment immigration very much in the way it is written. Unfortunately, if you read it on the face of it, you may think that they're really adding numbers for both and it looks good, but then you go into the fine print, into some of the assumptions.
Yeah.
And then it looks like it's really favoring family immigration, not employment
It's
immigration.
this nice bill that has a section of, here's all the employment-based numbers. Here's how we're going to increase by the employment numbers. Here's how we're going to increase the family-based numbers. And I like the sound of increases in visa availability, but if you go into the real nuts and bolts of it, they essentially tweak the calculations, which results in negative a loss for employment immigration, and the family folks are kind of made whole.
Yeah. So it's almost like in accounting where there is a number that's maybe $10 million, and you see that number and you think, wow, but you don't notice that on the left of that number, instead of plus, you ended up with a minus. So you end up losing that number, not gaining it. So the equation looks great. All the pieces look good, but one of them is assumed zero. Yeah. So basically what they've done is basically they said that we will not allow an overflow between the family and employment. So all the overflow that's coming into the employment base becomes zero.
Yeah, so this only, though, covers really the period from fiscal year 2020 to present, really. More really impacts fiscal year 21 and 2022 calculations. So this bill, it's out there and it's moving along. The DHS needs funding, and it's made it out of it has a committee report in the House, and then the Senate has just released their version of the bill. So it's the bill that is moving along and that has a reasonable chance of becoming law. And then there's the budget reconciliation, which everybody seems to say is teetering on the edge of reaching agreement that in theory can become a law. So it's really, there's these two competing things out there. Sam, are they incompatible?
And that's what we were discussing, right before we went live. We kind of start our conversation, for everybody knows, about 20 minutes, half an hour before, as if we are in there. We just forget about the time and we go, oh boy, we got to go live here and talk about it. So we were having this discussion before we went live, and you proposed that these can both be adopted.
Yeah. So I mean, it really deals. The only fiscal years mentioned are, and I won't go into details of how they all work, but are really 2020, 2021, and 2022. All right. And the one that's in the budget reconciliation bill goes back to 1993. It seems that the Mang amendment it's included in the DHS bill is about really undoing the wrong of the pandemic, undoing the negative that has been done to the pandemic. But there's still the problem is we still had a visa, as I said earlier, we had a visa recapture, not a visa wastage problem well before this pandemic ever showed up.
But let's pause that discussion for a second, because and that's where we want you to comment on this. And we want to take your comments. So we're going to start watching your comments here on this question. So here's what she's done. And I'm looking at her legislation here on the table with my scribbles. Year 2021 and year 2022, these fiscal years, they're assuming, or for the purpose of the calculations, that there will be no overflow from family-based to employment-based.
Yeah.
Right?
Yeah.
And also the flow back to the family-based, which we know that in effect it's really hasn't happened.
Yeah.
That there's no flow back. So they're saying these flows are zero, and we know we got 120,000. What's that number in 2021?
2021, I think it's 150,000 family visas out of the 226 typical allocation that they did.
That went over, and then 2022 similar number.
Yeah.
So they're saying that these numbers, there's no crossover. There's no flow from the family into employment for the purpose of reallocating visas, and then we can look back and look at the numbers, and then we will figure it out in terms of who gets what. But it looks like the family gets most of it. There's some language that says, in consultation with the Secretary of Homeland Security, shall allocate the visa made available as a result of the computation on a proportional basis consistent with Section 203 of the Act.
So we talked about this, and that refers to basically you keep the same proportional breakdowns. Your employment categories get this much, et cetera, et cetera.
Yes. Yeah. So ultimately, this does not help employment based. As a matter of fact, it hurts employment based
because they zero out this calculation.
Yes.
But the family based, to finish, I mean, I can't help but mention it. It's basically undoes the fact that they weren't issuing those family-based visas. It puts them back. It tries to make them whole.
Are you setting me up with my mouse not working, bro?
My mouse was turned off. Is your mouse turned off?
Well, is this our wonderful assistant? What's her Megan?
Yeah,
turns it off.
No, and she's better.
She's amazing.
She's yes.
She's amazing. All right, sounds good. So now my mouse works. So let's get rolling here. So we get people with great questions. We're asking, is this family lien legislation a fair solution to the pandemic? And I'll start the conversation with that. One thought says that there was no contemplation in the law to take that many cases from family to employment. And this is due to pandemic. And therefore, it really shouldn't. The employment shouldn't benefit.
It's an unprecedented situation. And
but what situation then would be the overflow be accepted? So, what scenario would that law contemplating?
Yeah, that's the government. The government doesn't do it. It doesn't do its job. Okay. What is the law contemplating? That there was nobody demanding these visas. That's what I understand it.
So we got comment here. Wasn't the Ming Amendment part of the 2020 bill as well, and it was taken out from the final version of the bill? Why would it pass this time around?
Why wouldn't it pass?
Well, it's sausage. Legislation is making sausage. Last year's flavor is different than this year's flavor. Momentum, emotions. There's a lot of intangibles that goes into what works this year versus what does not work last year.
I mean, I'm going to pose it to the public. We have an allocation of family-based green cards, and due to this darn pandemic, they didn't get them. Should we give them back to those people, or should they be forced to lose the last 2 years of waiting on the family side of the visa bulletin?
Why is there a law then written to allow for the overflow? What scenarios were they contemplating?
Well, again,
I'm asking.
I think it's got. I mean, the law was written to provide for the overflow for a scenario where nobody wanted those visas, and that's why you allow them to go to the employment category. And we have family-based cases in our office, Sam. People desperately want those visas, and they're stuck. The NVC, the consulates aren't bringing in family cases.
Okay, I will take your argument, your point. You're very well taken point. But I will also, yes, you're welcome. However, there's always however, right? If the laws on the books are so outdated, because that hasn't happened.
Yes, people want to immigrate to the United States for sure.
Yeah, and the family is backlogged for decades, right?
Yeah.
And these laws were written back in 1992, right?
Yeah.
It was back in 1992 when they wrote this, because it assumes the year 1992 zero and they move on. Okay. Don't only fix the family. This fixes the problem with the family immigration. It doesn't fix the problem with the employment. So they're interfering with the current law because the current law is outdated, right?
Yeah.
If the current law is outdated, why are you fixing the family immigration and not fixing the employment immigration?
Yeah. Why are you going to penalize that provision is in the law, and it's finally helping somebody? And why are you taking it away now?
And why would you take steps to fix that small piece of it and not fix the failure of the administration year in and year out? Why would Miss Grace Meng, who I'm sure is a wonderful person with a pro-immigration agenda, doesn't have the guts to say, you know what? Not only the family immigration is broken, the employment immigration is broken, and it's broken since 1992 as well. I propose the family is whole and the employment is whole. She gives something that completely penalizes the employment.
I will give you my take on that. No, I'm sorry, Sam. And this is a little facetious here,
Sure.
But no, the employment system has worked this year. The most employment-based visas are given away inside the United States to people who are here. Those folks got their green cards. In fact, they probably got more than they deserve pursuant to the current law. Now let's make the families whole again.
Except for 750,000 people.
Well, okay, so this goes back to, is it fair? And so is it fair? Does it feel fair in maybe the narrow context of this pandemic? Maybe a little bit, because those families have lost 2 years of waiting, and there's visa bulletin.
I got people waiting for 10 years.
I know.
Here as well.
I'm not defending it.
I know. I'm telling you, but no,
the big picture is it's not fair. It's not fair.
Yeah.
It's why is there a 10 year backlog?
Yes.
You know.
Yes, I agree. I mean, but I think the Meng Amendment, in my opinion, is not a cool amendment. Let me tell you why it's not a cool amendment.
I don't think there could ever be a
it's
cool
not.
amendment.
It's not cool because it is definitely. Let me tell you what a definition of unfairness. A definition of unfairness: if you're fair only to a group but not to another group, that's unfair. Fairness could be equally unfair to both groups. That's fair. Equally unfair, equality is important. And I think the Meng Amendment, is one-sided. And that's my opinion.
Yeah.
For whatever that's worth. I mean, that's basically, I feel that the Meng Amendment is it's not fair.
I mean, it's a very fun roller coaster read as you read it, because it sounds like the employees are going to get a little bit more as well, until you start putting your equations on paper and you say, oh, they've zeroed out.
They killed the overflow.
Yeah.
But okay, fine, we will take that. So the good news is, obviously, there could be a big recapture of visas for a long time. We don't know. It's not gone. But there also could be a negative. Now, I don't remember the split in the Biden bill between employment-based and family-based, and I wish I can get that report in front of me.
Oh, your wish is my command, sir.
Yeah, because I'd like to look that up. But if you take that, okay, I think it does. There's that one chart that has the
the yearly the chart from the very end of this report, which I'm going to pull up for our benefit here.
Yes, because it's going to show how many green cards we're able to allocate now if both of them are adopted, right?
Yeah. So let me see here.
So we're looking. So So
USCA recapture. So it says total of 940,000 green cards under the USCA, and the USCA reads a lot like what's made in the budget.
So does that include the overflow or not?
I don't believe so. I believe it's
231,000. What's that 231,000 number?
That's the administrative recapture, which is I don't recall.
So what's an unused family? Available green card under the USCIS. Okay, recapture this. Right, that one all the way. Just put on the screen here. Everybody can watch with us.
Okay, so let me see if I can.
And if you can't do that, we'll come back to it.
No, we'll have to come back to it. Also, everybody will get the joy of seeing me going.
Yes, absolutely. Yes. Yeah. So anyway, so what's that number again?
So under the USCA, that's the legislation, the proposed legislation, which this is what's in the reconciliation bill is closely mirrors, is 940,000
for both.
Yeah, I believe that covers both categories.
And that's split between
split across employment and family base.
And what share? That's what I'm trying to find.
I do not recall. I would recall being about 50-50,
right.
Honestly.
Yeah.
So not enough to to totally eliminate the employment-based backlog for India, but makes a nice dent in it.
Yes.
Yeah. Basically, yeah.
Well, we need to analyze it more because I think we'll probably bring it up to everybody next week on what it is, because it's relevant to see the impact. And also next week we'll know more about what Congress is doing. So that's what we got, and see if there's anybody.
Oh no, I mean this. I'm going to put up a comment that is really kind of hits the heart of the issue. It's discriminatory. Our system.
Well, number one, let's talk about the word discriminatory, because discrimination is not necessarily always illegal. So we start with that understanding, because people say, well, discrimination is bad. Well, someone with a discriminating taste, you say the word, right? Someone with discriminating taste, that means it's good taste. So in all laws are discriminatory. All laws are discriminatory because it creates groups of people and gives certain groups advantage and other groups disadvantage. So it is not. But is it discriminatory from a negative perspective? I think I wouldn't say discriminatory with complete difference to our viewer. I would say it is unfair because it just looks at somebody's group's problem without looking at the other group's grievance as well.
Yeah, I mean, well, ultimately, it's kind of reflective of our system. We have a per country based system versus an employment basis based upon employers' need, whereas we kind of obliged to bring up what kind of systems do other countries have. It's like a merit. They call merit based.
Yeah, the per country allocation is an absolute failure of any system. I mean, we've talked about that before. I mean, country like India that represent close to 20% of the world is treated like a small country, with a massive ability to produce talent, or China for that matter, to a country like, for example, Bahrain, Rome, that has,
Yeah, I mean, I take generally. I mean, the whole system basically has per country limitations. It's India gets the same allocation as the Vatican, and ultimately, I guess it has the idea that there's some sort of perfect allocation based upon number of people from each country, and what does that do? Maintain the status quo? Does it prevent demographics from shifting? But ultimately, the world's a small place, and it's getting smaller.
Is my explanation tomatoes?
I
think so.
Tomatoes.
Yeah, I think
are you calling yourself out, Sam?
Well, I put it here for he's saying it's the same thing. I mean, discrimination is it legal discrimination? It's the same thing. Where is this not being treated right? And I think absolutely, I agree that there is definitely a disregard to H-1B visa holders in this country, the talent and the impact they make to the economy and to our competitive advantage, and we come out with an amendment like the Meng Amendment, completely disregard this group who've been
It
here.
presumes that the system. It kind of presumes that the system, as it has gone for the last 30 years, has worked really well. You know, the system got knocked off the rails for the last couple of years. Let's put it back to where it should be, and let's maintain that long line. That's not fair.
Yes, I agree.
Yeah.
Sounds good. I agree. All right, so we will let you guys. So to kind of conclude, we still have great hope of an excellent recapture bill that can recapture up to over 900,000 green cards, potentially, if that continues.
That, for the record, kind of rights the wrong in the system.
100%.
It's offensive to me when the government doesn't do its job, and basically, I mean, I don't think the government doesn't want to issue visas, but why shouldn't these visas be issued? That is,
if you didn't file 940,000 cases,
I might get a word from say. I think I might get a pat on the back first for Brian. How did he bring in 940,000 cases
to the office?
Yeah.
So if you don't do 940,000 cases, I think they can charge you criminally responsible for beyond negligence. And the government, year in and year out, failed to and created a massive backlog and a true crisis. And no big deal. And everybody's saying, yeah, sure, no problem. Life goes on. That is discriminatory.
Well, I'm just thinking about this. You know, I am not an immigration encyclopedia, and I'm thinking about back all these years. You know, what happened in, and I'm scrolling through these numbers, Sam.
Mm-hmm.
What happened in 2009? Allegedly, they had a failure to use 10,000 family-based visas. Why should those have ever been plucked out of the family base? Obviously, they would have rolled over to the employment category, but why should those ever been plucked out of the family based?
18,000, 2012.
Why should they have ever been? I mean, I'm sure those things were I miss my mind's blown. They couldn't find there wasn't 10,000 in 2009. There wasn't 10,000 people family based cases who were looking to immigrate to the United States. It's
how in the heck 18,000 in 2012. I mean 22,000 in 2007.
Well, yeah, this bothers me. 2012, 18,465 family and also 311 employment visas not given out. Yeah. I was an immigration attorney in 2012. Not a chance in hell that there were 311 people who said, "Nah, we don't want those." Yep. I don't know. I'm sure that
but the Meng Amendment for INS or USCIS, Homeland Security, now to adopt it as they're in the budget.
Pat ourselves on the back. We fix
it. Doesn't fix it.
Yeah,
it doesn't fix it. I mean, once you have the guts and say, you know what, we adopt this one. We adopt Biden's bill, okay, to hand back 940,000 missed green cards.
Yeah, I guess what I say is, why should they ever expire in the first place? Why must they expire? I mean, it's written into the law, but why should they expire in the first place?
You're right on. That legislation should be all expiration provisions retroactive from 1992 is hereby null and void.
Yeah,
and you're done.
Yeah, we would have a lot less problems if the backlog would probably be less if they just said, hey, these things never expire. You can keep them in one category and they never expire. Yes. Maybe, I don't know.
Yeah. So the Meng Amendment is there. The Biden proposed amendment is there. They're not gone. They could both be adopted, or one can win out. If the Meng Amendment wins out, that would be a true disaster for employment-based.
Yeah, but I mean, they don't seem incompatible,
And we are not getting any hints that Section 60,002 is going to go away. We have no information out there that there's any opposition to it.
If you guys want to do some research, type immigration and reconciliation bill, and you're going to hear about the legalization.
There have been some Republicans that said we don't want to do it. We don't want to do it, but I'm not sure they're vocal.
Yeah.
Or because would the parliamentarian object? That's what the piece that I would be interested in. But I think she's probably knocked off twice. Maybe she's now gun shy because now there's a momentum to
Well,
overrule
and we
her.
talked about there's precedent for doing something like this before, and there was no objection. It was 2005, I think it was.
Yes.
So
All right, sounds good. So let's get comments from people.
yeah, let's
Um,
scroll around in this
yeah,
section
see if there's anything
see if there's
on this
anybody.
issue.
Yeah.
Before we move on.
Here's a good question. What can be done to increase efficiency and liability from USCIS? Can only Congress bring change in USCIS?
Well, the failure of the government goes beyond immigration. The FCC. There are all kinds of stories about the FCC failing to monitor the stock market and all kind of insider trading that happens. It causes millions of dollars for people. Our government lacks accountability. Hardly do you see somebody get fired.
Oh yeah, my favorite one is the Federal Election Commission. It's a totally impotent body that can't do anything and can't impose penalties against anybody.
You know, they botched the testing tools. Remember during the beginning of the pandemic?
Yeah.
And nobody got fired. We failed things, and we come out. We admit, I don't want to get into politics, but on the international front, the withdrawal from Afghanistan wasn't done well. I'm sure somebody miscalculated. There's no punishment. Nobody is taking responsibility. That is not only an immigration law.
Yeah.
That is at all levels of government. In this government, in this system, our American system does not seem to punish government officials for not doing their job, and that's a problem.
How do you fix it though?
I don't know. You fix it by voting, but voting doesn't fix everything.
That's
a
theory. That's
a dream.
That's the least common denominator. This is the sticky sauce of it. It is you vote. In law school, I remember my election law teacher said, "You vote the bastards out."
Dream on.
Yeah. Do you expect any other political parties to massively revolutionize the way the U.S. government runs? No. If one wants to do it, the other one doesn't want to.
You have to accept that our system of government is inefficient.
Yes.
And it is a zigzag, is never a straight line, and there's a lot of unfairness and unjustness in the way it's carried out, and that's the way it is.
Well, I want to go a little bit deeper. What about USCIS itself, Sam? How do you fix USCIS right now? They have a pandemic problem. They have a people problem. It seems to me. Obviously, it doesn't fix all the visa recapture stuff, but the wastage, the 80,000 wastage from that happened at the end of fiscal year 2021, we don't have the people to do it. We don't have clearly enough to do it. And I guess the mental logic in there is: do we bring on people to fix this issue when we may not need them after this pandemic is over? I guess is the question. But ultimately, USCIS has lots of huge backlogs. So they can use more people.
That is a massive problem that we have with USCIS, but how to fix it, it's beyond me, because obviously we had a prior administration that basically tore it apart.
Yeah.
It was not well taken care of. It was not preserved. And when this administration took over, there was a lot of catching up to do, and the pandemic, and those issues compound and cause delays and inefficiency, unfortunately.
Yeah, I'm seeing, as a comment here, allocate money to the budget and hire folks, modernize systems. They primarily allocate money in the budget to hire folks, modernize systems. They primarily run on fees. Yes, indeed, they run on fees. Are you advocating increasing their filing fees?
There has to be a carrot and a stick, and there's no stick.
Yeah.
A carrot doesn't fix it. You eat the carrot and you want to eat another carrot. But there has to be a stick, i.e. a punishment. There has to be an incentive and there has to be a disincentive. And if you don't have a disincentive, you don't have accountability, ain't going to get fixed.
What's the possible disincentive for this? I don't have an answer. I really don't know.
There has to be, the ombudsman is the weakest body. The ombudsman is an office that's outside USCIS, within the USCIS, but it's an independent body that talks about, there has to be 25 ombudsmans everywhere, and there has to be a recommendation.
No, people get away with things when there's no enforcement, and you need somebody to enforce the rules on the enforcers.
Yes.
Yeah.
Yes.
Yeah.
So, and you have to have a punishment. You have to say, we recommend the removal of the director, some kind of an outside body that says, we recommend the removal of the director of this agency. They have failed meeting the minimal standard that we think is acceptable. A body that recommends that, and some kind of a binding process that there can be a way to remove people who are incompetent. Unless you do that,
then you start running afoul of removing people through administrative processes. You're going against the political appointments, and then that's a whole other issue.
No easy solution to that.
Yeah.
All right, guys. So don't panic yet. The Ming Amendment is not the final thing that's going to happen. Potentially, it may or may not. We don't know. So we will let you know. We will keep you posted. And let's go take some questions.
Yeah, I'm still optimistic. I'm
Yeah.
I'm liking what I'm hearing on the reconciliation bill.
Okay, good.
Okay, so let's just go from the beginning and see what comes up in between. We'll just jump
All right.
around, see what we get. So even if we just use AP EB3 for entering the U.S. while maintaining H-1B status, wouldn't I be eligible for fresh I-45 when the EB2 becomes current? So it is possible. There's a policy out. I think I understand the question. Basically, if I enter the United States using advanced parole, but I'm maintaining my H-1B status, can I file for adjustment? So there's a policy out there, Sam, by which you can resume your H-1B status after entering.
Is that for the extension?
That's for an extension. You got to. So basically, it is. I will keep it short and I'll say it is possible to resume your H-1B status after you return from advanced parole.
If you join your same H-1B employer and file for an extension back to H-1B, that's a very old memo. And I would assume that USCIS will still honor it today. But yes, it is possible. But if you enter on advanced parole and not extend, you're a parolee. And if you're a parolee, you cannot file for an adjustment.
Yeah, you have to be in status.
Yes.
Yeah.
Good question.
Yes. So here's a good question. So when is a dependent considered to be on green card EAD? Is it with when a social security number is approved, or when is it used for employment?
Excellent question.
Yeah.
So let me rephrase that question the way I understand it. So let's assume a dependent is on H4, okay? And then they file an adjustment of status, and the parent is on an H-1B. When are they on green card EAD?
Well, I would say
It is not when you receive your social security card.
I agree with that.
Cross that out.
Yeah.
Right?
Yes. And well, the other answer is when it's possible is when it's used for employment. And
Yes.
the answer is yes.
When you take actions inconsistent with the H4 requirements.
Yes.
And under H4 law, you're not allowed to work.
Yeah. To be in valid H4 status, you have a valid I-94. You are the spouse of an H-1B worker, and you can only work pursuant to your H4 EAD if you have one.
Would you be considered a green card EAD if you take education or school?
Generally speaking, H4s allow education. Yeah.
So that would not get you in the green card EAD yet if you've taken education alone. But if you've taken employment, then yes.
Yeah, it is out.
That's the moment.
There's two boxes: is that what's allowed for H4, and using that EAD is outside of it. It's not a problem. It's not really a major problem to use the EAD. It's just you, in theory, lose the benefits of the protection of having that non-immigrant status and the pending adjustment of status.
Yes, that's a good question.
Yeah, there's no. I gotta emphasize though, there's not an alarm that goes off that says whoop, 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 whoop. You
Say that again.
This is a noise I use a lot. Saying that says, hey, you don't get a letter in the mail from the government saying, oh, we see you used your green card EAD. You're no longer in immigrant status. It's not something that happens. It's you hand that card to your employer, and they enter it in their I-9 records, and the government probably never knows that it's used unless they ask.
I think probably the moment you sign confirming your EAD, you enter your name and then your work authorization.
That's manifesting intent.
And then you hand the green card EAD as your employment authorization.
That sounds a lot like the intent you were talking about.
That might be the moment in time where congratulations, have become a green card.
And then a door opens out of nowhere. An immigration office says, no more H4, closes the door, and you're done.
It's all about the behavior of the person.
Yeah, I mean, big picture is make sure you're either maintaining your H4 or you're using that EAD properly.
Yes.
Because the most scenarios, I'm very much love talking about 2 layers of protection, but most scenarios, employment-based green cards go fine, and
Yes.
there you go. So let's see here. So my priority date is July 2014. I got a downgrade to EB3, and I got this August EAD for myself and spouse. Well, good for you.
Mhm.
But I didn't get AC21 / travel document for my son. Open to service request, but no update from the past 1+ month. Please suggest. So basically, if you didn't, you got EAD AP for you and your spouse, and not for the child. I have seen this a fair amount. Is there any logic behind it?
No, there's no. They're just basically it's a training problem.
It's something something got put underneath something else, and presume I've had this happen, and eventually they figure it out, and eventually they issue the straggler case their documents, but It just takes some time.
Yes. Now, the key here, so we can close this 100%. Obviously, if you're maintaining your H-1B and your son is maintaining their H-4. And you travel abroad, you're not invalidating your adjustment of status. But if your son leaves without getting that advanced parole, then it's a problem because your son have abandoned the adjustment of status. It's not the end of the world, but it complicates your life substantially because you have to enter on H-1B and H-4 again to be able to apply for I-485 again. You cannot come back on advanced parole because your son cannot come back on advanced parole and cannot come back on H-4 if you come on advanced parole. So you got to come in on H-1B, your son has to come on H-4, then you got to refile your adjustment. Obviously, nobody's thinking about traveling, but to kind of close the loop on this, to mention that piece.
Sam, I see a question here, but I see a favorite from a favorite perennial question, which we're going to come back to soon. So if I use AP and maintain my non-immigrant status, so as we discussed, I'm going to already chop this question up. Using your AP and maintaining your non-immigrant status aren't necessarily a true thing, because if you come in as a parolee, you do not come in as a non-immigrant. You have to take action, get your H-1B extension likely too.
But we got to define what does it mean I use my AP.
Yeah.
So the only way you use your AP is to leave and enter the U.S. on advanced parole.
Maybe somebody's referring to the EAD. Yeah.
If you work on EAD, you're not automatically on AP or on advanced parole. You're not a parolee.
Yeah.
If you use your employment authorization document, if you're on H-1B or H-4 in the U.S. and you accept employment in the U.S. outside the H-1B employer or as an H-4 anywhere in the country, you become a person authorized to stay in the United States pursuant to the director of the Department of Homeland Security or the Attorney
General, which delegates that authority to Homeland Security.
Yeah.
They have their rules, yeah.
So you're authorized to stay in the United States pursuant to your pending adjustment of status application. You're not a parolee, okay? What's the difference? Highly legal, highly technical, but clearly you're not on a non-immigrant status, and which means that if the adjustment is not approved, it's a problem. If there's a denial, inadvertent denial is a problem. Also, you cannot file an I-485 application on an EB2. Let's say you're on an EB3 and EB2 becomes attractive. You cannot file another I-485. But so using AP, I don't know what that means, except that you've left the country and came back, to my knowledge.
Yeah.
So what's the question here? Because there was a question. If I use my AP,
can I file a new I-45, or can I only do interfiling?
So interfiling, you can.
Yeah.
You got to be in status.
Yeah, and your priority date has to be in status to file adjustment of status. Interfiling, you can do it if you're not in status. Your priority date has to be current. Final action date has to be current for your
or within the INA 245K rule.
Yeah, or the INA
within 180 days
for filing adjustment status. Yeah, so that's something to always keep out there. But Sam, I mentioned there's a question, my favorite question.
Yes.
It's and somebody who's very self-aware, ABC acquisition guy.
All right, I love it.
Thank you. Well, first, thank you for taking my questions prior.
Certainly, our pleasure.
Prevailing wage pending with A, but I want I-140 with C. So what stage can I switch process to C as employer, recruitment, perm, or
Prevailing wage pending with
A? Yeah.
And
But he wants to do the I-140, though, to go through the process with C. So at what stage can I switch that process to C as employment, recruitment, perm, or so at what stage is it? Is it recruitment or perm or I-140 or after I-140?
Okay, so let's remind everybody of our friend's question. So there are three. There's A, who owned by B, which is also owned by C, and the prevailing wage is filed with A, and our friend would like to finish up the green card with company C, which owns B, which in turns own A.
Yeah.
So, Brian, obviously, permanent labor certification with A, you got to stick to that and get that done 100%. Then you got to file the I-140 with A. You cannot really do anything.
Yeah, I mean, you're already in the process with A. Your prevailing wage is filed with A. You're going down the path of A. It's really easy to file if A and C are related.
Just start all over again.
Yeah.
I mean,
prevailing wage is pending. Prevailing wage takes 5 months, and we've heard this question for about 3 weeks in a row. So you got some time on it. But it's very easy. I mean, presumably A and C are closely related. They want to offer you the same basic position. It's very possible for C to file a substantially identical prevailing wage.
But to answer the question, that's not the question he asked. The question is, how can I end up with C and continue my green card application? I think 2 opportunities.
I think I know what they're going to be.
Well, you tell me the first one.
Well, the one that immediately comes to mind is pretty far down the road. It's got to be a supplement J, a portability of adjustment once your adjustment's filed. 180 days pending adjustment, you can say, I'm going to take a different offer of employment.
That's many, many years down the road.
Well, I said it's many years down the road. What's your other idea?
What about successor and interest?
Well, my memory is a little bit fuzzy as to A, B, and C and their relationships. But if A gets sucked up into C, C takes up on the immigration liability, basically takes on the right parts of A. In theory, it's possible that C could absorb A in such a way that the I-140 could be re-upped with C.
But that occurs during or after the I-140 petition.
Yeah.
Yeah, during or after the I-140 petition,
Yeah.
you can claim successor and interest, which means company C has assumed all immigration liabilities.
Yeah. That's assuming
A
goes poof and no longer exists and gets absorbed. That's the requirement
Yeah.
for that. You
And
can't
it's
just
right.
change because
It's
you
right.
feel like it. A has to be sucked up
Yeah.
into C.
Yeah, and if A remains as an entity, then you have one answer, which is supplement J after that adjustment file.
Yeah, but begs the question though, if your plan, I mean, can you really do that? Can you really file that adjustment with company A in good faith if your plan is to change to C?
Company C. Yeah, that's a good question too.
Yeah. Well, I'd say, like I said,
However, that's kind of a technicality. If company C owns B that owns A,
I could name a bunch of scenarios by which you could just basically say, very much say in good faith, I want to join C now. It's called I want my green card. I'm happy to join A, but 180 days later, C made an offer, and if I can legally get a green card that way, sure.
If they're co-owned, there's no. I mean, the lack of acceptance or willingness to work for A is really answered by accepting C because C owns A. I mean, you can make a decent argument.
Yeah.
I don't think USCIS will fight you too much on this.
Yeah.
All right. I like it. That's a good question. Thank you, SB. We appreciate it.
Have we finally answered it? We'll find out next week. I like perm green I-140 related questions. So I'm going to just sort of keep on going along here. Any possibility for EB2 India Retrogression? Any possibility in fiscal year 2022 final action date for EB2 will move to November 2013? To 2013 in January.
I'm not looking at the visa bulletin to answer that question. Talk to me after the budget reconciliation bill passes.
Yeah. Then
until then, we really don't have answers to those questions because. And again, I'd like to listen to our friend Charlie here soon.
I think he's doing it on the 26th, which is tomorrow. Well, I'll be watching it.
Yeah. So with that in mind, I think it's probably a good question for next week. We can probably answer some of it. But honestly, if they're saying they're going to pass the House reconciliation bill or the budget reconciliation bill soon, that's even better. Right after, right?
Yeah.
That means they have until December 3rd.
That's when
when
they've extended
the deadline. So
yeah.
they're going to pass it before that date, and it's after that we really can answer a lot of those questions.
Yeah, we do know that bill, if that gets passed, it seems to mean movement forward.
It depends on which version.
Yeah, well, yeah, there's the yeah.
All right.
So this sounds so we have filed concurrently I-45 and I-140 together in the past month. EB3 downgrade with priority date of May 2013. Son is turning 21. Ooh. If we get EAD, can our son use this EAD when unless our priority date becomes current? So,
well, EAD is unrelated to. Sounds like the son is turning over 21. That's if they adjust. So it's a great question. Of course, he can until the decision is made. They're worried about the son aging out.
Yeah.
The using filing date, not final action date. So if it just got filed,
it might be presuming the son is aging out. That's kind of how
that's what I'm.
My son's aging out. Can you still use this EAD
until a decision on the adjustment of status is made?
Yeah, then it's not a. It's. I mean, I would question the premise as to whether or not the son will age out. I mean, if you've been able to file an EB3 downgrade, you have an EB2 that is out there, and EB2 dates are moving forward. I would say, yeah. I mean, this is something where you talk to an attorney about this because CSPA.
Well, clearly, if you don't upgrade your I-140 to pre-processing, please.
Yeah, that's
a please, because if you upgraded your pre-processing to your I-140 to pre-processing, you have shortened the additional time that could be added onto the child age for the purpose of the Child Status Protection Act, because the pre-processing is bad for your son's aging out.
Yeah.
So that's one thing. Secondly, it all depends on the dates. Did they say May, right? May 2013?
Priority of May 2013. How close is that to current for EB2? It's a while off. It's about a year and a half off.
Yeah.
For current.
I would definitely not upgrade the I-140 right now.
Yeah.
And buy all the time, possibly if you have an RFE.
Yeah.
And see what happens, right?
Yeah, to give everybody the context, the Child Status Protection Act essentially gives you more time, and that time that they give you is based upon how long it takes the government to approve your I-140.
That's one of the criteria.
Yeah.
And then the second criteria is if the final action, so retrogression will not help you, but if it reached a final action date, if you reach the final, so forward movement can help you if they move the final action date forward.
Yeah.
And there's visa availability.
Yeah,
then
it's looking to be more likely for EB2 right now, but who knows what EB2 is going to do?
Yeah, I would definitely right after. I mean, clearly don't upgrade to premium processing, and then right after the bill passes and they release the next visa bulletin.
Man, that's a cool part of this bill. Not only will it give people, make more green cards available, but I just think of all the kids out there who are going to become 2021. If they do that at the right time, there'll be people who's
locks them up.
It'll make sure they might have never gotten a green card.
Yeah.
And that's an unfairness in the system that will drive me mad.
Yeah.
People were forced to wait 10 years. If the system was a little bit more fair, that kid would never even have to worry about this issue.
I mean, the damage is irreparable.
Yeah.
For the children's aging out for the last 30 years.
Yeah. That's those 30 years of
government inaction and failure to do their job have aged out so many children, and how can you reverse that?
Every unused visa for a year is potential of some kid not getting a U.S. green card.
A bunch of kids.
Yeah.
Unfortunately,
I wasn't thinking about that. I don't like that.
Yeah. No.
Yeah. It's upsetting how no matter how much you think about it, I guess. So. It's a great question. So if they give back that's $150,000 to the family base, it seems utterly useless. And basically, can they process them? Sam,
the Ming Amendment.
That's a good point.
Keeps them available indefinitely until they're used up.
Yeah, how long will it take though, Sam? If there's, USCIS has its problems right now, and clearly they have a people problem where they're taking them a long time to process cases. The Department of State, how are they doing?
They're coming back online, but they're not doing
They
very
people. I mean, the news stories regularly for not to get into politics, but the years of the last administration, people were leaving.
Yeah.
People were leaving, and
They're well. I mean, they are definitely impacted. I mean, in places like India and China and Philippines, heavily impacted. But the Meng Amendment makes them available indefinitely. I don't know whether the Biden bill makes them available indefinitely. I'll be curious to see that. We'll read into it. Maybe we'll report back.
I mean,
I have not even looked into.
We spend our time being wowed by the numbers.
But there's no way they can process 1 million green cards in 1 year.
Yeah.
That has to take another decade to resolve.
Yeah, that's literally 1 million.
They're going to take this I-485 form and they have to reduce it to 1 page and accept applications and lock numbers, and then during that time send another form to complete the application.
Yeah, and that's the thing with something we've come up before. It's why can't just let people get some of those benefits, file a case, and
well, they do that for the H-1B.
Yeah.
So the H-1B visa, before they approve a single case in 5 days, they say, "Oh, all the numbers used up." No, the numbers were not used up. You haven't approved a single H-1B.
Yeah.
But they have no problem locking everybody out. When it comes to adjustment of status, oh no, we haven't approved them yet. They're wasted. Yeah. Allocate these numbers early, so we can go into a system like that and solve the problem.
Yes. So I got a question here. Does USCIS waste family-based numbers every year similar to employment-based? So I have
more, as a matter of fact.
Yeah, I'm looking at a chart here. Well, we all know what happened in 2020. 122,000 lost. Let's go back, scroll up a bit. 2004.
How about year 2000? They've wasted 52,000 family-based cases and 31,000 employment.
Yeah, I just can't imagine.
What the hell? Oh, it's a Y2K, right?
That's a glitch.
Well, it's the Y2K crisis. I don't know what were they doing in that year that they kind of
screwed up. Here's where these numbers irritate me, though. In 1999, they family-based unallocated about 2,300. 2000, 52,000 unallocated, and then 2001, 2,600. What the heck happened there?
Well, I mean, have you seen 1999 employment-based?
Gee, 1999, 98,000.
100,000 green cards.
Yeah.
We got to put that screen here for everybody's sake next time. We didn't set that screen up to share. Our apologies. Maybe we'll share it next time.
What I should do is I put in the comments a link to this Niskanen Center report. Yeah. It's just an interesting.
We'll put in the comment that page so you guys can see it.
Yeah. Gonna keep on going. So let's see what Ritu Jain here has. So we have filed I-45 and I-140 concurrently in September. EB3 downgrade with priority date May of 2013. So hey, I may have done this one. So I realized that I have repeated the question we've already done. So I'm going to just smile and move on.
All right. No problem.
So
worst case scenario.
Yes. So what is the worst case scenario when multiple I-485s are filed for the same primarily applicant? Can USCIS deny one or more applications? Have you seen any such cases before?
No, never. There's no worst case scenario. You have all upside, no downside.
I can invent a worst case scenario for you. I'm going to fill in a whole bunch of facts, but I can do it.
Do it.
Okay. Imagine you have filed 2 adjustments of status. You got a family with you. And one of them, your child has been locked in under the Child Status Protection Act, and the other one, he is not. And they approve the not one. In that situation, your child doesn't get a green card.
I'll have to say you win. Brian. So the worst case, that's a great one, and explain it, Brian, since it's you had the presence of mind.
Now I gotta show your work. It's high school math class all over again. So essentially, under the Child Status Protection Act, they judge your child's legal age and whether their ability to get a green card is locked in based upon the I-140 petition that underlies the adjustment of status case. So under one adjustment of status case, your child's priority date could be locked in pursuant to a particular I-140. If you file a adjustment of status pursuant to another I-140, there's a different analysis based upon that different I-140. Your child's birth may not be locked in. And suddenly you have this nightmare scenario where if your adjustment of status is approved in one category, your child may not be eligible for a green card, and the other, yes.
Yeah. An example we had recently, so we'll give numbers here so people understand. We had somebody who filed under EB3, and the I-140 took 306 days to approve.
Mhm.
So because the I-140 took 306 days to approve, then you add 360 days to the age 21. So the
He gets the better
child,
part of a year more for his date to become current.
yeah, almost 10 months, right?
Yeah, it's about
10
2 months.
months.
Yeah.
10 months more after the child reaches 21 to age out. The EB2 I-140 took 6 days.
Hence why Sam doesn't, was saying, watch your child with premium processing on an I-140.
It took 6 days to approve. So under the Child Status Protection Act, for a child under the EB2, the child gained only 6 days beyond the age of 21 in terms of protection. Now, which of the two protection you like more? The one that gives you 10 months or the one that gives you 6 days? And if you file two adjustments, and assuming, for the purpose of our discussion, the final action date locks in, right?
Yeah.
And, rewind, assuming that the final action, the didn't lock in, the filing date, if you file under the filing date or dates for filing, the dates continue to progress for both children beyond the age of 21. Now they are 21 in 1 month. Guess who aged out? The EB2.
EB2, yeah.
So that child under the EB2 application will be denied. The child under the EB3 application
Still got time for his priority date to become
and
current.
as a matter of fact, in that specific example that we were looking at, once the final action date is reached, the date stops.
Yeah, you're locked in.
You're locked in, and then if retrogression, that child now is locked in.
He's still getting that green card. He could be pushing
Now it
30,
can take a while.
Yeah.
He can get the green card. Whereas under the EB2, so you need to compare the Child Status Protection Act. That's a scenario. That's the only possibility that you have to be careful with.
Yeah, I mean, if you don't have to worry about that stuff, it's called, I'll take what I'm going to kick back, relax, approve whatever case. I'm happy to do it. And
anytime your child is over 19 years old, you need to look at this.
Yeah,
in my opinion.
Yeah, I mean, you need to. Yes, if you're adding another path is when you really need to look at.
All right, take last question.
Okay, so I'm going to, we went through a bunch of them. I'm just going to do a random scroll, and I'm going to pick one and spin the wheel. I'm going to try this one. What do we got?
All right.
Now, if the person walks across the border from the U.S. to Mexico and goes back using gets back using H4/H1/H4 I-797, which are valid using automatic visa revalidation when the status flips to H status.
So now if the person walks across the border to U.S. Mexico and gets back using H1B, which are valid using automatic revalidation, will the status flip to H status? Absolutely yes. The status does flip to an H1B status, but you have to present your I-94 at the border. The problem, and I have had an actual case like this, the problem I see is there's no clear documentation of a person getting back to H-1B status. We had a situation where there was an adjustment file and it was denied. I'm taking back, this is almost a couple of decades back, long time ago. Because
they couldn't fathom how you were in valid status because you didn't have a good.
There's no stamping.
Yeah.
Mexico doesn't stamp. The person left, and the person now in the U.S. filed an adjustment, and then they said, "How did you come to the United States?" And we said, "Visa revalidation," and they said, "There's no evidence of it. There's no stamp. There's nothing." So we were able to prove that.
What did you do? FOIA the customs?
No,
folks?
what I did is he got a sandwich before the he got a sandwich on credit card right before he crossed the border. Then when he crossed the border, he made another purchase. So we pinned down two purchases: one on the one side of the Mexican border, the other on the other side of the Mexican border, within about an hour time.
Yeah.
And we said he crossed the border. And by the way, he has an I-797. He has a stamp. So don't assume he crossed illegally, because this guy's an engineer and he's always followed the law and he's been here forever. And they approved it.
I like sandwich-based law. I'm a big fan of sandwiches.
Sandwich-based law.
Okay.
With that, we end today's session. You guys have a great day.
Thanks, everybody.